We're going to call the meeting to order. We do not have a quorum, so therefore we will begin as a committee just to hear the bills, but we will not be able to vote for them. The first person we have on our list today, we have before us 5 measures that are here in the committee today. One of them is on consent, which is SB 927 by Anderson, the Public Utilities District Act, elections of directors. That is on consent. The other items will be heard. My understanding is the first person up will be Senator Hill, followed by Senator Hernandez, and then Senator Leno, and then Alan Hertzberg. We'll be listening first to SB 816. Senator Hill.
Thank you, Madam Chair and members. SB 816 ensures that the contribution amounts above $100 to Board of Equalization members are subject to the BOE's existing disclosure and recusal rules. As Board President Fiona Moss stated in her state support letter, these are reasonable restrictions that will strengthen public confidence that the Board decides cases based on facts and the law, independent of inappropriate influence. And BOE member George Runner wrote in his support letter, SB 816 will not create a burden for board members since contributions are currently tracked. The bill is also supported by California Common Cause and the California Public Interest Research Group. I respectfully ask for an aye vote, members. Thank you.
Okay. Are there any other supporters, any other witnesses?
Nicholas Heidorn with California Common Cause. We are indeed in support. We think this lowering the recusal threshold will help ensure the impartiality of the board.
Thank you. Any other persons in support? Any opposition?
Hello, Jerome. Good morning. Didn't see you down there.
Snuck in. Oh, I did that last. Members, there we go. I hit my knee last time, so I want to make sure that I avoid it, if you will. Thank you, Madam Chair and members. I want to also thank Senator Hill for his engagement in this process. Has been very enlightening in a number of ways for myself. I want to call the members' attention to the federal decision as of May 17, 2006. The court confirmed the Supreme Court ruling that provisions in 816 excuse me, are unconstitutional by virtue that it impedes the freedom of speech of individuals by lowering the contributions without any evidence or factual basis for doing so. In the state of Montana, they attempted to lower the amount to I believe, $320 for all statewide elected officials and $170 for the rest of the elected officials. And the federal court issued a summary judgment and saying that this matter is unconstitutional. They wouldn't take it up. This measure in itself arbitrarily lowers the contribution limits from $249 to $100 without no documented evidence to support doing so. It does not change or address the concern as it relates to arbitration or the aggregation of contributions. In fact, the case in point was a case where 3 members of the Board of Equalization had accepted contributions, and those contributions were considered by the press or one particular individual to have been aggregated, and when in fact they were not. The contributions were received as of 2013, and the case in point that came before the Board of Equalization came before us in 2016, 2 years subsequent to the 1-year statutory limit. In that particular case, even though in my case I actually accepted the contributions, considered them to be aggregated and subject to the conflict of interest, and voted against the taxpayer in chief. Other colleagues in similar positions voted for the taxpayer, and so thus the reason I really am in a good position to be where I am today in opposing this measure based on facts and law. The bill has several unintended consequences, members. It does nothing to increase this disclosure at all. Doesn't modify, doesn't change anything relative to the disclosure law. In fact, the Board of Equalization has the most restricted disclosure provisions in any elected official in the nation. Pursuant to Regulation 7011, the Board of Equalization is required to disclose any contributions to the Board of Equalization with 30 days of anyone appearing before the board. Relative to the transparency issue, it does not modify transparency law at all, has no impact whatsoever on transparency. In fact, one would argue that it actually weakens the existing transparency by lowering the contribution limits. It enhances the potential for gaming the system. So a member can be conflicted out and recuse himself, and the public will have no idea whatsoever why they recused themselves because of financial restrictions they may have had. The other concern about this bill relative to the unintended consequence of members is that it imposes a civil and criminal penalty. Doesn't impose, strike that. The measure, as a result of lowering it from 249 to 100, now causes citizens who traditionally in the past were not subject to the civil and criminal penalties, they will now be subject to the civil and criminal penalties of the existing COP Act. Thus is the reason that major business organizations are opposed to the measure. California Small Business Association, VICA, which is one of the largest business organizations in Southern California, the Federal Business Organization as well. Civil rights organizations oppose it because it violates the civil rights of small contributors who have no CPAs, have no lawyers. They participate in the process just by virtue that they want to voice their opinion. Unfortunately, with this measure, those individuals will have to report those contributions, which are currently required to be reported anyway, but would be subject to the penalty if they make a mistake. If they make a mistake and fail to report it within 30 days, they're subject to the penalties provisions of this law, which makes the bill unconstitutional, and that it violates the freedom of speech, due process, and equal protection under law. From an equal protection perspective, it gives candidates for the Board of Equalization undue advantage over existing incumbents as it relates to freedom of speech. Under McCullen versus the Federal Election Commission, as well as McClutchin versus the Federal Election Commission, and Russell versus Sorrell, the Supreme Court has said repeatedly reducing contributions limits based on mere perception is a violation of an individual's freedom of speech. Lowering the contributions to such a low level without any reason for doing so other than a perception is also a violation of freedom of speech.
Mr. Horton, could you sum up, please?
Yes. In summary, members, the unintended consequences of the bill is my primary concern as it relates to just the average citizen. The average citizen being subject to these penalties is just fundamentally flawed and fundamentally wrong, and creates an inherent challenge, I think, for transparency as well as disclosure in the process by having these unintended consequences that could occur without our knowing and without our control and accidentally occur.
Okay, thank you. Are there any other persons in opposition to the bill? Okay, no one else is in opposition. Any comments or questions from the dais? Yes, Mr. Harper.
Thank you very much, Madam Chair. In crystallizing the intent of this bill, if I can get some clarification, typically you have this $250 limit because that would be a trigger of corruption, and I think this was set in the early 1980s and has never had a modification based upon inflation or cost of postage with the Levine Act and others. Is the contention of the author that $100 in an election that encompasses 1/4 of the state would cause corruption?
Mr. Harper, the reason the legislation was brought forward and the part that the opposition discussed and mentioned that there's no valid reason for this and it doesn't make sense to do this. But the reason is that in recent years, firms have begun to circumvent the intent of the law. A BOE's members' reelection campaign received 45 contributions of $249 each from executives, attorneys, and other employees of a tax consulting firm totaling over $11,000. Now, they don't have to recuse themselves unless they are specifically appearing before the board. So they were able to make and aggregate those contributions, and that was the problem. That was that came to light last year and was the impetus for the legislation. Another board member received 25 contributions of $249. So what we're seeing is a circumvention, a loophole in this law that allows those who want to influence the BOE to be able to do that with the existing $250 limit. We want to lower that so that it will be more appropriate and less of an opportunity to provide that. And if a member wants to, if a board member wants to, here again, to recuse themselves, they don't have to recuse themselves. They can just give back that contribution of $99 in this case, or $249, and then would not have to recuse themselves. So it's not a burden on the board members. The freedom of speech issue that was raised as well is constitutional. Well, if it didn't apply to $250, it's not going to apply to $100 either in terms of the question of the constitutionality of the limit on this. And what I thought was interesting is the unintended consequences, the disclosure law. Well, that's not the goal of this bill, is disclosure. Or transparency law. That's not the goal of this bill, is not transparency. It's the recusal issue that is still possible, and the ability to put some limitations on the amount of aggregation of these contributions from large firms that then will be able to influence the board members.
So why does your bill not include anything that accommodates for inflation as well as the increase in cost and postage? You know, in the Levine Act, when the $250 was set in that location, $250 bought you X amount of postage. But if you were to buy the same amount of postage in today's campaign for 2016, that would be worth probably about $650 or so dollars in order to be able to afford the same amount, being able to send to the same amount of people.
Correct. Mr. Harper,
It's almost like it's going in reverse.
Well, because the goal is to avoid the aggregation of campaign contributions that then can unduly influence board members. There is no whatever the legal campaign contribution limit is that applies to BOE members is still in force. This is just the amount of money that would be applied to those who are in the potential for a conflict of interest.
Well, if I may note, I'm having trouble figuring out, even if you aggregated to this $11,000 figure, you're running your BOE, it's not like you're running in Woodside or Los Altos Hills, which maybe have a few hundred voters that are in those respective cities. Each of these folks are running in 1/4 of the state of California, the largest city or largest state in the nation with almost 40 million people. And so $11,000 to try to communicate with that many voters, I don't see how that makes a substantial difference in anyone's campaign who's running for Board of Equalization.
Well, we're not talking about the campaign. We're talking about the potential for a conflict of interest. They can still raise as much money as they want outside. This only applies to those entities, those individuals who would be appearing before or have issues in front of the Board of Equalization. It has nothing to do with any citizen, any campaign, any firm, any company, or any contributor outside of that. This only applies to those who have business before the Board of Equalization.
Well, Madam Chair, I just think that all this does is just push campaign contributions to independent expenditures, which is less transparent. And I don't think that this amount has any substantial difference to any elected official who's worth their cents in terms of having a impact on a campaign for 1/4 of the state of California.
Okay, thank you, Mr. Harper.
Madam Chair, may I
Very briefly, if you want to respond, yes.
Members, the COP Act was enacted in 1999. Since then, there's been a significant number of Supreme Court rulings that have said that the contribution restrictions provisions in the COP Act are unconstitutional. Most recently, May 17th, as in the Doug Hiller case in Montana, where the federal court concurs with the Supreme Court. If you look at the government code, FPPC code, specifically says that members are not allowed to aggregate contributions. The contributions in questions were treated, despite the perception, were actually treated as a conflict of interest, and accordingly, members would not have voted or could not have been able to vote on those cases had the cases came within 1 year. The cases did not come before 1 year, so there wasn't a problem. And since the enaction of the COP Act, no member has violated these provisions of aggregation because there's a $10,000 penalty for every time you do. You can be prohibited from participating in the political process for 4 years, and is considered a misdemeanor, something no one's going to take the risk of aggregating or accumulating contributions.
Okay.
Madam Chair, if I may respond to that, the aggregation.
Very briefly, okay.
Thank you, but the aggregation that we were discussing is absolutely correct. The aggregation only applies if it's a conflict, if those individuals are going to appear before the BOE in any form. The other aggregation from the same company of those members, those employees, those partners of those companies that are not specifically appearing before the BOE, their contributions are accepted, can be aggregated without conflict.
Okay, thank you very much. We don't have a quorum, and while I appreciate this conversation and the author's desire to protect us against the perception of impropriety at the Board of Equalization, I'm not necessarily convinced that lowering the threshold on an already restrictive conflict of interest law would fundamentally change things at the board. I'm not sure if we go from 250 and people can legally do 249, if the people are smart enough, you do 100, they're going to do 99. I mean, I'm not sure if doing that would result in anything that would be different at the board. We've had one bill, and now this is the second bill, and which kind of concerns me a little bit because it's obviously a reflection of some things that's going on at the BOE. As I told my staff, I've learned more about the BOE in the last 2 months than I've ever wanted to know in my whole life. And I almost feel like making a bill to eliminate the BOE. And I know there have been efforts to do that, when I see what's there. But clearly, there are some issues that are here, but I'm not sure if lowering the limit improves it at all. I don't know, and it seems as if there'd be people recusing themselves even more on a very small board, because if the limit is at 100, then you're going to have more folks with issues or more folks that they can't hear issues on. So it just seems extremely complicated in terms of that. But I understand what you want to accomplish with it. And obviously, there's some issues that are there because the 250 is not a high number for contributions these days. And 100 is generally what people do at school boards, maybe. But even school boards now do 250 and above. And so it really is an interesting concept. And but I think it's a reflection of some other issues, much more than the money issue that's there. And that concerns me most of all. So this is the second bill we've heard on this. I've not weighed in on it because I don't see a solution. At the same time, I don't see a great harm in it either, in terms of what it can and cannot do. Because if things are going to happen, they're going to happen. People will, I've learned folks will figure a way around almost anything if you really put it out there for them to do, if that's their intent. We're talking about the Hill bill. I don't know if you want to weigh in. I'm listening to Zaire, and I had a conversation with you this morning. So if you wanted to comment on it, they both have presented their sides. I don't know if you had anything that you wanted to contribute.
Thank you very much, and I'm sorry that I arrived late, but I want to support your bill, Mr. Hill. I appreciate all the work that you do, and I will be supporting this bill, at least so that it moves forward today. But my question was just given what's the difference between $249 and $99? That was.
Oh, of course.
Given that these are members who represent almost 8 million residents in their respective districts, you're talking about a very large area, and so I just wanted.
And I appreciate the question. And as I mentioned a few minutes ago, the concern has been, and what brought this to light, is you have a $250 limit today, but what that turned out to be is when a law firm was able to circumvent the $250 limit by having 45 of its employees, attorneys, people within that organization aggregate $249 checks to a BOE member, which totaled about $11,000. Now, the question is raised, well, they can't aggregate. Well, they can aggregate. The only people who can't aggregate are those who actually specifically individually appear before the BOE. We're talking about the employees of a company. So we're not talking about $250 as a lower amount. We're talking about $11,000 in this particular case. And that has occurred numbers of times. So obviously by bringing it down to $99 to make it a legal contribution from a firm that does appear before, that limits the amount, limits the influence, and probably would limit the ability of someone wanting to do that because the dollar amount would be so low. We're just trying to make sure, since this is the only elected taxing body in the country, that it should be something that is clean and without influence. And this, I believe, bill would do that, make it a better opportunity for that. So thank you for the question.
It's the only reason I raised the question also is because in an era where we're spending so much money in campaigns, I mean, if anything, all this should lead to eventually, for either our body or the voters eventually saying that public financing is going to be the only real mechanism of making sure that there's a appropriate medium for campaign contributions to meld into the political process, and there not being significant influence or perceived influence. So.
It's a sad
again,
commentary here.
I'll be supporting the bill, but I just don't know if this measure will be able to really effectively change what's been going on. I think it's only going to, if what you're saying is the case, then it's only going to force more people to then contribute 99. So, but thank you for your work. Appreciate it.
Thank you. We have a quorum now. Could we have roll call?
Weber.
Aye. Here.
Harper.
Present.
Travis Allen.
Here.
Gordon. Lowe. Mullen. Nazarian.
Present.
We have a quorum.
We have a quorum. Okay, in that case, is there a motion for this bill?
Madam Chair, I don't believe Member Nazarian had an opportunity to hear my concerns as it relates to.
Very briefly, please.
This member Nazarian, first, thank you for sharing your thoughts on this. The bill exacerbates the potential gaming of the system, which is inherently challenging, reducing it from 249 members of the general public, the elected, the corporations and CPA firms. They understand that law. In no way are they going to violate the law. No way our members have ever violated the law because of the penalties involved in that. The aggregation is just a red herring. It doesn't exist, has not existed. As the consultant has pointed out in his analysis, aggregation, if you solicit the client, if you're involved in the case, if you participate in the process, and you're part of the firm as part of the analysis, the lawyers and so forth, you're treated as part of the aggregation in the process. The individuals who can aggregate are secretaries, the janitors, and so forth and so on. But most of the folks in a law firm or accounting firm who are actively involved in the case, they don't have to physically appear before us. They simply have to be involved in the case in order to be restricted under the existing COP Act. That's a red herring. It's simply not true. Government code says it. Committee consultant has pointed that out as well. Since this bill was the original COP Act enacted in 1991, the Supreme Court has said that this is unconstitutional. It violates the freedom of speech. But the inherent challenge with this, you have small contributors who never before were subject to civil and criminal penalties, who now, if they make a mistake, the unintended consequences of this bill is that they will be subject to civil and criminal penalties.
Okay. Thank you. Any other questions? No. Any comments? Okay. Thank you. Any other comments from the committee? Mr. Allen.
Thank you very much, Madam Chair. Have there been any documented violations of the current limit of $250, or is this more of a perception?
Violations of the $250, well, the violations would be if you violate the conflict of interest issue, and some members may have to recuse themselves. The issue that I raised was the fact that there is a firm in Southern California that aggregated 45 contributions that equaled about $11,000. So at $249, so they used that loophole in order to make a contribution, and then that firm represented a client before the BOE. And they're able to do that today. The only aggregation comes from those members who go before the board.
So I guess I have a couple of questions. The first is, theoretically, if that was a larger corporation or they just chose to diversify the aggregate contributions among a larger employee base, they could have been below a $100 limit, correct, at $99, and potentially gotten much more money. This bill still would not combat that, correct?
It would highlight it. Nothing, there's always a loophole that people find a way around things. This just makes the impact of it and the influence less because of the size of companies. I mean, we could say it could be the post office could have every employee giving a contribution, and we're talking thousands. But that's not necessarily the reality of the workforce in many locations. So this will put more I don't say transparency, but it will provide a better opportunity and put more controls on the only taxing, elected taxing board in the country. And what I think we want to make sure is that there is the transparency, that the conflicts, if there are identified, would be publicized and allow those members to recuse themselves, one, or to return the contribution if they feel that there is then they would not have to recuse themselves.
Member Allen, this bill says nothing about aggregation. Nothing. Nothing about it. The only thing it does is lower the contribution from $249 down to $100. If the intent was to deal with some alleged concern about aggregation, just simply say you can't aggregate contributions. There is no violation, hasn't been no violation, because if it was, members of the Board of Equalization would be in jail. There are no loopholes. And the loopholes, any contribution, and no one treats a $100 contribution and not report it at such a low amount, because you got a $10,000 penalty, a misdemeanor, and you can be barred from being in office. This is simply not true. It's a red herring. The FPPC concludes that it's not true. The consultant said that's not the case in its evaluation. Government code said it's not the case. This is just an opinion of.
Okay, we want to.
And it also, if I may, Madam Chair, is that the fact that this does not limit the campaign. Whatever the legal campaign contribution limit is, that's fine. This is just to identify a potential conflict of interest.
Okay.
That's all this is about.
Okay, I think we kind of understand what's going on. You have another question? You finished?
No.
Thank you.
No further questions. I appreciate the clarification. I have to tell you, just at this time, I have to agree with Member Horton. I really don't see an issue here. I truly don't. I think that if any individual is going to be swayed by an $11,000 quote unquote under the limit contribution, as it were, or as it is proposed to be, I think they're going to have a lot bigger problems that this bill would not necessarily correct. And I don't think that this would actually get at the root of that problem. However, if there are issues where we have, any kind of graft or corruption at the BOE or any state office, I think they should be rooted out immediately, and I'm sure there's appropriate penalties for that. So I appreciate the concept behind the bill. I really do, because I think what you're trying to do is admirable, and we all want to make sure there's no undue influence from which members are not recusing themselves, whatever body they happen to serve on.
Okay, I think we had some folks who came in late who just simply want to give their name and their position on the bill.
Apologies, Chairwoman. Emily Rash, the Director of CalPERC. I apologize for being late, but we are registered in support of the bill. Thank you so much.
Support of the bill. Thank you very much. Is there anyone else support or opposed to the bill? Okay, fine. That having, is there a motion in favor for the bill? Bill's been moved. Is there a second? I'll give a courtesy second. Okay, roll call.
The motion is due pass and already referred to the Committee on Appropriations. Weber?
Not voting.
Weber, not voting. Harper? No. Harper, no. Travis Allen? No. Travis Allen, no. Gordon, Lowe, Mullen, Nazarian, Nazarian, aye. We have ayes 1, noes 2.
Okay, fine. Okay, we'll keep it open. The other members are here somewhere, and they should be in to vote. Thank you very much.
Madam Chair.
Thank you, Madam
Thank
Chair,
you.
members.
That brings us to our second, the person, Mr. Leno. Senator Leno is next. Yes, let's have a motion on consent. We have one consent item, SB 927, Senator Anderson. Does anyone want to remove anything from consent? I guess not. We only have one. We have a motion and a second roll call.
The motion is to pass and recommend consent. Weber?
Aye.
Weber, aye. Harper? Aye. Harper, aye. Travis Allen? Aye. Travis Allen, aye. Gordon? Lowe? Mullen? Nazarian? Nazarian, aye. Ayes 4, no 0.
Okay, that's out on consent. We will keep the roll open for those who may be late coming in. I understand I have to go and make quorum somewhere, so I'm going to turn this over to Mr. Harper. Mr. Lynn.